Assalamualaikum warahmatullahi wabarakatuh. My name is FIZRAN BINTI Muhammad SANI. My matric number 1212363. Today our group will be presenting about fatwa as an authority in civil court in Malaysia. The first slide is about the definition of fatwa. As we see in the slide, fatwa is a legal opinion or ruling on a matter of Islamic law issued by an Islamic scholar known as Mufti. Here we could see that Mufti will give his legal opinion or ruling which is on a matter that based on Islamic law. There is various definition about fatwa from Muslim or even Western scholar. Therefore, I would like to point out two definition from a book which is called Fatwa dalam Perundangan Islam 1981, written by Osman Ishaq. The first one is Al-Badakhshi, defines fatwa as a legal decision on hukum syara issued by a mujtahid, and the second definition is from a Western scholar, which is D.G. MacDonald, defines it as a formal legal opinion given by a mufti in an answer to a question submitted to him either by a judge or by a private individual. Therefore, here, from this definition, it can be concluded that fatwa is an answer to unprecedented cases which issued by a qualified and authorized body or individual. So in this slide, I will be explaining about the history of fatwa. The first one is during the Malacca Sultanate, which it is before the arrival of British colonial. The Sultan acts as the judge for trial of cases with the assistance of ulama. The assistant of ulama acts as the advisor for the Sultan, and the Sultan holds the highest position in the court, and the Qadi position was put under court hall, which is now known as Sharia court. Right now, we could know that the Islamic law was the basis legislation system in Malaya back then, which is before the arrival of British. However, after the arrival of British colonial, we could see how they changed the landscape of legislation system in Malaya, because they had been declining the importance on the role of Mufti and Fatwa. British intervention officially began with signing Pangkor Treaty on 20 January 1874 between British and Perak. Consequently, British resident became the advisor in all affairs except custom and religion. They spread their ideology on various aspects related to political and administrative affairs, which is including the judiciary system with their introduction of civil law. Thus, this reducing the Islamic legal status in Malaya legislation, which until it affects the court hall. Therefore, the court hall was no longer exist. The closure of court hall has erased Islamic values in the legal system, and it was replaced by civil law. However, it didn't last forever because most cases in Malaya are dealing with Muslim affair. Therefore, the civil judges do not have the expertise to resolve the dispute among the Muslim. And the British colonial have no choice but to recognize the Islamic law, fatwa and mufti under the supervision of British advisor. In some state of Malaya, the British have set up the mufti post in the judicial and legal system, especially in issuing fatwa. And in the state of Strait Settlement, mufti and fatwa also play their importance as reference in the judgment. However, the Islamic law was reduced and limited to certain cases like the Islamic family law, because British managed to influence the legal system in our country with their interpretation and the notion that civil law is much better than Islamic law. Later came the introduction of Subordinate Court Act 1948, whereby the Fatwa and Mufti position are at the state level. Although they are at the state level, they are still considered as authoritative and will always be consulted as reference to other court judges, whereby their authority will always be recognized by law at the state level. I think that's all from me. Thank you.
My name is Noor Aisyah binti Muhammad Noor ARIB and my student ID 1212366. So let's move on to the authority of fatwa in the civil court. First and foremost, we must understand that a fatwa is not binding and enforceable unless and until it is published in the State's Gazette. Other than that, we must take note that a fatwa that is not published in the Gazette shall have no force of law. Next, let's talk about the enforcement of fatwa. The enforcement of fatwa can be referred to Section 34, Subsection 1, Subsection 2, Subsection 3 and Subsection 4 of the Administration of Islamic Law Act 1993. So, in this section, it states that the Mufti should make or publish in the Gazette, either on the direction of the Yang di-Pertuan Agong or by his own initiative, as well as by the request. Besides, fatwa can be used as the reference in the undetermined cases or unsettled dispute that relates to the Islamic law. Other than that, in the Section 34, Subsection 2 of the Administration of Islamic Law Act 1993, it states that the Mufti's statement shall not be taken as a fatwa unless it is published in the Gazette. Under this provision, it is crystal clear that the fatwa is binding not in its capacity as a fatwa, but because it is a legal instrument. The section also states that the fatwa only can be applied to the Muslim only and has no legal effect over the non-Muslim. Furthermore, a fatwa which is passed by a state legislative assembly or in the parliament shall be authoritative laws for the Sharia courts of that particular state. So, since the administration of Islamic law is under the administration of the states, the state has full discretion either to accept the fatwa. Last but not least, in the Section 34, Subsection 4 of the Administration of Islamic Law Act 1993, it states that the fatwa shall be recognized by all courts in the federal territories as the authoritative for all matters that led down therein. However, we must take note that the civil courts may also refer to fatwa to any matter relating to hukum syara or Islamic law in a manner as provided by law. Next, let's move on to the status of fatwa in the civil court. The status of fatwa in the civil court can be referred to Section 38 of the Administration of Islamic Law Act 1993. First of all, we must understand that fatwa will only bind Sharia courts and not civil courts. So, in this section, it provides that the Mufti shall be not liable to be summoned to any civil court to give opinion or evidence relating to Islamic law. Lastly, other than the Sharia court, the other court may request the opinion of the Mufti and the Mufti may certify his opinion to the requesting court. So, under this provision, it is clear that if there is any Islamic law issue which arises in the civil court, the court may request the opinion of the Mufti. Besides, the Mufti also can appear himself as a witness before the court. Next, not all the fatwa or Mufti statement can be taken as the reference in the court because there also the fatwa or Mufti's opinion or Mufti statement that is not valid to to be used as the reference in the civil court.
My name is IZZATI SYAZWANI binti ZAIDI. My matric number is 1212376. Now I will continue with the related case of Datuk Bentara Luar. This is Haji Yahya Yusof and others against Hassan Omar and others. I will going through to the fact of the case, issue of the case and summary of the case. Next, we will move to the fact of the case. A piece of land had been made as a wakaf by the late Datuk Bentara Luar of Johor, Muhammad Saleh bin Perak, in favour of his child, Osman and Kalsum. The respondent in this case was his child, while the appellant was the administrator of the said estate. Datuk Bentara died in 1915 and the land was registered in his name. The appellant sought to sell the land and distribute the proceeds but couldn't because the respondent have caveated the land. The appellant's application to remove the caveat had been dismissed because the question of the land's title must be resolved first. The appellant sued the respondent by claiming inter alia that the wakaf was invalid. The court held that the wakaf was valid, hence this appeal. The appellants submitted that the wakaf is not valid on two grounds. The first ground is the wakaf was created mainly for the benefit of some of the wakif descendants. This ground referred to Muhammad Ahsanullah's case and Abu Fatah case. Second, the land was still registered in his name, and by managing it as his own, the wakif never permitted the wakaf to take effect, nor did he intend for it to have any impact at all. A wakaf to one's children and descendants is valid under Muslim law according to counsel for the respondent as applied in Johor's Wakaf Prohibition Enactment 1911. Next is the issue of the case. There are three main issues in this case that the court had pointed out to decide whether the wakaf are valid or not. The first issue is the court emphasized the scope and impact of the Johor Wakaf Prohibition Enactment 1911, which came into force in November 15, 1911. The second issue is to determine whether the decision of the Privy Council in the two cases mentioned above apply to this wakaf. The last issue is whether the Datuk's following action had any impact on the wakaf. Next, we will move to the summary of the case. The wakaf is valid for the following reason. The first reason is the law applicable to determine the validity of this wakaf must be such as that interpreted by Muslim scholars that learn in Islamic jurisprudence, unencumbered by rule against perpetuity, a concept alien to the system of jurisprudence. The second reason is the Privy Council's decision in Ahsanullah's case and Abu Fatah's case do not apply because the system of appeals to Privy Council from the decision of courts in Johor was only introduced in 1920, and at the time when the wakaf was created, the law as interpreted by Privy Council decision was not yet part of the law of Johor, and the application of the rule against perpetuity ever since it was introduced in the Malay states, including Johor, in 1937 has always been accepted by a saving clause to exclude disposal of Muslim properties according to Muslim law for the operation of the rule. The third reason is, as the wakaf took effect immediately, the subsequent conduct of Datuk does not disprove the existence of the wakaf, nor does it affect its validity. The appeal is therefore dismissed with cost, and the deposit is to be paid to the respondent against tax costs.
My name is NURUL UMMI binti YAAKUB and my matric number is 1212369. So now I will continue about the recommendation of this topic, which is Fatwa as an authority in civil court in Malaysia. It is a suggestion that if there are Sharia issues in a case in a civil court where the case is outside the jurisdiction of the Sharia court because the first reason is one or all of the parties in the case are not Muslim. That means the person that involved in the case is a non-Muslim. Second, there are civil law issues, for example, land law, company law, or common law principles, in addition to Sharia issue such as wakaf or right of child custody. Then, the civil court should sit together with a judge of the Sharia court to discuss about the case. We don't have to create a new position. Existing Sharia judges can be borrowed because such cases are extremely rare, perhaps only happen a few times in a year. it will not involve a reduction in the jurisdiction of the Sharia court, as the cases are indeed outside the jurisdiction of the Sharia court. In fact, it will increase the powers of Sharia judges and will give exposure to Sharia court judges to the experience of sitting in civil court. Next, the function of the Sharia judges is to advise the judges of the civil court on a Sharia issue. The civil court judge will adopt the Sharia judge's decision on the Sharia issue in deciding the case. State governments no need to worry because it does not reduce the jurisdiction of the Sharia courts, but rather increases the powers of the Sharia judges. The federal governments also did not lose anything. All political parties should support because there is no politics in this matter, and it will solve problems that have not been solved for a long time while giving the benefits to all of the parties. Last but not least, the conclusion for our topic, Muslim and non-Muslim will get benefits from this rule. If in the past, non-Muslim, including the Islamic Religious Council, did not have an avenue to be heard in court if the issue that involving them was a Sharia issue. It is because the case was under the jurisdiction of the Sharia court and they were not Muslim and could not appear in the court. But today, the case will be heard in a civil court that existed by a Sharia court judge. So, indirectly, this matter has given many benefits to all parties that involved. So, that's all from our group presentation. Thank you very much.